introduce Jeanne Singer. Jeanne and I have known each other for probably couple of years. Started initially through Rotary.
We met in the womb.
And I've had the privilege of working with Jeanne both for friends and family over the years. She is a very unique individual in the sense of having her certified public accountant degree as well as a law degree. And it makes for a wonderful combination as an asset and a professional in terms of knowing all the stuff that she does and being very helpful for individuals that might be looking at planning and providing and what might be needed with documents, forms, etc. And so we're very happy to have Jeanne here with us today, and thank you for being here to be part of our event. Thank you, Jeanne.
Thank you. I will try and keep everybody entertained. Nobody ever really wants to talk after lunch. Nobody ever really wants to listen to the tax attorney speak anyway. So I will do my very best to keep everybody's attention. I should have been doing a better job in passing these out while I was chit-chatting up at the front of the room. That would be fabulous. So I'm not necessarily going to follow the outlines. I prefer that we're a relatively small group, even though the room was big enough that you all hid in the back rows, but a relatively small group. So I want to answer your questions. So as I'm talking, feel free to interrupt me, ask questions, ask me to clarify. Tax attorney, I try not to do it, but there are times when I end up talking like a tax attorney, and nobody needs to be listening to that. So just ask me to translate into English, and I'm happy to do that. The first document that I want to talk about is a financial power of attorney. I'm a little unusual for a lawyer. Pretty much if you go into this kind of presentation with a lawyer, they all say everybody needs to have a will, and that's the first thing that they want to talk about. Not everybody needs to have a will. The state of Maryland, will usually get your stuff to go to where you want it to go. Everybody needs a financial power of attorney. There is no statutory default. So I think everybody over the age of 18 in Maryland needs a financial power of attorney, because you just don't know when life is going to interfere and get in the way. Both of my kids got financial power of attorney for their 18th birthday, because I'm just that cool of a mom. But they laughed, they rolled their eyes, they did the, oh, she's being mom again. But they have both used it. There have been times when they've been sick, when they've been out of town, where I have been able to step up and take care of things in their financial world. They are now 27 and 23, so their financial world is still pretty small, but things come up. But as we get older and we become full-fledged adults, they are not yet full-fledged adults, no matter what they will try to tell you. I tell them they are not a full-fledged adult until they stop texting me before they're coming home to see if I can schedule them a dentist appointment. That's my bright line test. But for those of us that have houses, we have cars, we have real bills to pay, we have health insurance. As we get older, health insurance and having somebody being able to communicate with your health insurance company is huge. There's a whole range of financial issues. A lot of times clients will come in and they say, well, we don't need to worry about that because mom added me to her checking account. And that's great. You're going to be able to pay the bills for mom, but you can't do everything else in mom's financial world. And there's a significant number of those things. Maryland has made this process a little bit more complicated in the last couple of years. COVID has completely distorted my sense of reality and time. In 2010, Maryland made a substantial change to the financial power of attorney law. So if they're not coming in saying, well, I don't need a financial power of attorney, mom already added me to the bank account. The other thing they're saying is, well, we've already done that. Back in 1995, mom did financial power of attorney and named me as her agent. Pretty much The General Assembly did not mean to. They meant well, but they stumbled all over themselves as they were making this change. They pretty much invalidated any existing financial powers of attorney in the state of Maryland that predate 2010. So there's lots of clients out there with documents thinking that they're in good shape. And when push comes to shove, when you actually have to go to the bank or talk to, or do something with the real estate, do something for your loved ones and your family members, you're going to run into difficulty because those documents are no longer considered effective. When Maryland made the change, they were trying to fix two specific things. Very few of them relate to us in Washington County. Is everybody a Washington County resident? Did anybody sneak across state lines today?
State and county.
County lines.
West Virginia.
Okay. So you've already heard this stuff, so I don't even worry about fixing it for West Virginia for you. The two problems that Maryland was trying to fix when they made the law change to the financial power of attorney, some of the big national banks were no longer accepting the general powers of attorney prepared by attorneys. They wanted you to use their in-house form. And sometimes that's okay, because mom's turned 90 and she's taken you in and she's added you as an authorized signer. But most times life gets in the way. And even if mom's 90, she's probably resisting a little bit about adding you to the bank account just yet anyway. They have a tendency to grab onto their independence a little bit more the older they get. So Maryland said, as a cost of doing business in Maryland, you have to have this if your clients have this statutory form of the power of attorney, you have to accept it. For the most part, it wasn't an issue here because the two banks that were an issue were Bank of America and SunTrust. We don't have a Bank of America here. Unfortunately, now that SunTrust has merged with BB&T and has become Truist, they have not yet started demanding the statutory form of the power of attorney, but we expect that it's only a matter of time until you will need the statutory form of the power of attorney to deal with any Truist accounts. The second thing they were trying to fix, if you remember back in 2008, 2009, when the economy kind of took a turn for the worse, there were lots of stories in the Herald Mail about agents that did bad things with the money. So now Maryland makes us put in black and white in the power of attorney, you're giving your agent a lot of power. Make sure you trust them before you sign this document, which was a conversation we had always had with clients anyway. I'm the oldest of 6. In theory, my father should be able to execute a power of attorney that names any of the 6 as his agents. In reality, that would not be a good choice. So, not just from a trustworthy standpoint, but, if somebody's not taking care of their own financial house, you don't want to put them in charge of yours. So if they're habitually late with paying bills, because most of my older clients, they pay the bills the day they come in. They're cranky with me if I can't give them an invoice when they come in to see me because they don't like to owe it to anybody. They want to pay it immediately. So putting a kid in charge of their checkbook who only pays bills once a quarter is just going to be a disaster. Too much tension between the family members. But now that black and white, make sure you really trust your agent. It can be difficult to get your family members to sign that document. Once I send draft documents to clients, that's the number one question I get. Clients calling me going, I'm not signing this. Are you crazy? Did you read that language that you put in there? Why would I give my agent this much power? And we're not giving them any more power than we were before. The state of Maryland just thinks by putting it in black and white that we will have more success. I'm a little bit more cynical than that. I think that if you ask the people that were taken advantage of in 2008, they thought they were putting their trust in the right person at the time they signed the document. I think a lot of those agents that did bad things were just thinking, I'm just going to borrow a little bit of money. Things are going to turn around. I'm going to repay it back. And unfortunately, that downward spiral, 2008, 2009, 2010, took a little bit longer. And they kind of got caught in the meantime. And I think the people who do bad things with your money are going to do and can sleep at night are going to be able to sleep at night even if we have language in there saying make sure you really trust them before you sign this document. The biggest issue that when Maryland adopted this new form is they now require 2 witnesses and a notary. So while Maryland has had a general power of attorney that's been around for 100 years or more, the old requirements only required one witness and a notary, which is what makes most of those pre-2010 documents invalid as far as most of the financial institutions are concerned. And something that Maryland did not anticipate is all the title companies now require the statutory form of the power of attorney. So if you have a general power of attorney and mom or dad has been diagnosed with dementia and you need to be able to do something with the house or to sell the house to provide for the cost of their care, you may not be able to handle settlement on their behalf. So hopefully they're not too far into their diagnosis and that you're going to be able to handle that for them. And why I say that that's the most important document is there's no statutory default. So if it turns out that you think that you've got a valid financial power of attorney in place and it's not, and your family member is no longer competent and capable of signing a new document, your only option is to go to court to be appointed as the guardian to be able to take care of their financial affairs. And then everybody needs a lawyer. It's like Oprah, the person who wants to be the appointed guardian needs a guardian. The court is going to appoint a guardian to the individual who they're seeking guardianship over. Any other interested person is entitled to have an attorney, and you need to have 2 doctors sign off on their capacity. So it's usually in an emotionally trying time anyway, as you're trying to take over managing the financial affairs for your family member. You certainly don't need to add a protracted court proceeding on top of that. And COVID, I thought I was a morbid estate planner, and that I had kind of considered all horrible situations for my clients. 2020, 2021, COVID completely blew me away. I was not nearly as morbid as I thought. There was significant chunks of time where the court system was shut down completely, and trying to get guardianship during that time frame was just about impossible. We do recommend that you name an alternate because life gets in the way. And again, morbid estate planner. During COVID, I had mom was already incompetent. She had named dad before she lost her competency as her primary agent. Named son, who lived 2,000 miles away, as a backup to dad. Dad and son both ended up on a ventilator at the same time, 2,000 miles away. So we had mom in a facility, things needed to be taken care of, the court system was not open, and I didn't have anybody who could take care of things for her. She was fortunate enough that she has a son with enough financial means that he pretty much just took care of everything for mom, and then once, thankfully, both dad and brother came off the ventilator, came home, and we were able to kind of square things up then. But not everybody has a family member who can just step up and take over, pay all the bills personally while we're waiting for an international pandemic to go away and for the court systems to open back up. And 2,000 miles away. I always name a second alternate if the kid's in town because the kid's always going to be driving them to doctor's appointments.
So if you have a power of attorney written after 2010, you're pretty much safe?
You should be. Double check and make sure you have the 2 witnesses.
Okay.
So for all the other documents, there's a statutory default. So that if you don't, so if you don't have a healthcare power of attorney, there's a list in Maryland law as to who has priority to make medical decisions for you. It may not be who you want, but there's at least a list. If you haven't written a will, the state of Maryland will write a will for you, or West Virginia. And 9 times out of 10, the assets get to the same place that you want them to. But there's no statutory default for the power of attorney. So if you don't have that document in place, and you need it, the alternative is to go to court and be appointed as a guardian. And I think I think the youngest individual that we had to get a guardianship for was 40. You know, I had 2 clients in their 40s end up in a coma within a couple months of each other. One had all their documents, you know, so he had his brother who was able to step up and run his business and do everything that needed to be done. The other, I had done business work for her husband. They kept talking about coming in to get their documents in place, and they hadn't gotten around to it yet. Because they were only 40. They had plenty of time. They didn't need to worry about it just yet. And she ended up in a coma, and we ended up having to do an emergency guardianship for her. So again, everybody over the age of 18 should have a financial power of attorney. Maryland's statutory form of power of attorney is actually available on the Attorney General's website. I probably thought about putting the link in the materials and then actually did not go back and put the link in the materials. But if you go to the Maryland Attorney General's website, the form is there that, you know, print it out, make sure your family members fill it in. But the key thing is having the 2 witnesses and the notary. One of the witnesses can be the notary, so you need 2 people. And it should not be somebody who's named. You know, so if mom is naming her 2 kids and the neighbor across the street is a notary, you know, you can have the neighbor witness and notarize, but don't have one of the kids who's named as an agent or their spouse serve as your other witness. 9 times out of 10, you know, there's nobody in the family that's going to pick the fight and challenge it as being invalid, but you just never know. So the counterpart to the financial power of attorney is the healthcare power of attorney. That in Maryland, that document is a 2-part form. So the first part, you name agents to make medical decisions for you in the event you're unable to. The second part, which is what most people think about, is the living will, where you get to say whether or not you want to be on a respirator or feeding tube, if you're terminal, if you're in a coma, or if you have an end-stage condition. It is not unusual that we just have individuals fill out the first part to name an agent, and they don't do the living will piece. Either because it's a little bit too much for them at that point in time. You know, so for some of my clients that are, with early diagnosis, you know, it's a lot to kind of talk through those differences. You know, they can kind of understand the 30,000-foot level, but getting down into that detail is probably a little bit too much for them. You know, for my kids, because you know, my kids also got the healthcare power of attorney when they turned 18. But as I said before, Maryland's got the statutory default, but that's not necessarily who you want making your medical decisions. Again, you know, I'm the oldest of 6. We have not agreed on anything since 1972. My dad at 84 just signed a healthcare power of attorney and a financial power of attorney and a will 6 weeks ago. I have been telling him for 30 years that the only saving grace is that, you know, if he had died in New York without a will, that my 3,000 clients would not see that he did not trust me enough to put a will in place. But, you know, finally at 84, we convinced him to sign the documents. Yeah, and a big piece was him knowing that his grandchildren were better prepared adults than he was at that point in time. But you know, my siblings and I have not agreed on anything since 1972. You know, and the thought of the 6 of us having to come to consensus about his treatment in the hallway was daunting at best. And I told him, you know, I'm not going to pick this fight with Susie. So you're essentially putting Susie in charge of your medical decisions. If that's what you want, go for it. If not, you know, sign the document. And next time I went up, he had signed the document that made my brother the power of attorney. So the medical power of attorney. I had a client that I had been working with for 25 years. I thought I knew everything about him. I had met his kids, I had met some of his grandkids, I had met his girlfriend, and he would not sign a healthcare power of attorney. because he's young and he's healthy and he's gonna live to, another 20 years. He's only 82. He's got a good 20 years left in him. And I said, okay, that's fine, and his two sons did not get along. I said, that's fine, but, in Maryland, because you're not married, the kids would have priority, and the two of them would have to agree to the course of your care. Turns out that, he was separated from his wife for 45 years. Neither one of them believed in lawyers enough to get divorced. I said, well, if she's going to be in charge of your medical decisions. He came in the next day. So while it's nice to know that the state of Maryland has provided some of these statutory defaults for us, they're not necessarily who you want to be in charge of those kinds of decisions for you. There is a lot of confusion between that document and the Maryland Order for Life-Sustaining Treatment. I know we put that form in the back of your in the documents for you. So the Maryland Order for Life-Sustaining Treatment, which is quite a mouthful, is the new DNR, the new Do Not Resuscitate form. And I'm dating myself because new is probably 15 years now. But lots of clients. So the primary difference from a family standpoint is if your family member has done the living will and the paramedics are called to the house, the paramedics won't look at the living will. They do everything they're trained to do, and then they transport your family member and the living will to the hospital, which is not a bad result. So Maryland doesn't have a prescribed living will. They have a suggested form, and that should be in your documents as well, and is also available at the Attorney General's website. And just needs 2 witnesses, doesn't need a notary, but 2 witnesses that aren't named as an agent. But because there's no mandated form, and there's only 2 paramedics that are called, and they're doing heroic work, but one of them actually has to be driving the ambulance back to the hospital, and we want the other one doing what they're trained to do, not trying to interpret a legal document while the ambulance is flying down the highway to determine what they're allowed to do. So they will just ignore it completely. They'll take it with them and hand it off to the hospital when they get there, and because then the emergency room's working on your family member, and there's somebody in the back room reading the living will to see what they're allowed to do. The Maryland Order for Life-Sustaining Treatment, or the MOLST form, is a check-the-box form. It's front and back, so it's something that the paramedic can be hanging from the wall of an ambulance, so that they can be looking up and seeing what you checked, so that they know whether or not they're allowed to do that while they're transporting you. But we've had a couple of instances, particularly right after Maryland made the change from the DNR to the MOLST form. And Maryland actually, invalidated all existing DNRs when the MOLST form was put in place. And the doctors did not necessarily understand that, so we had a fair number of individuals who were sitting on DNRs and the family thought everything was in place, only to have the paramedics come and say, well, we can't look at that document anymore. And then we had one client live for another 3 days at the hospital. Family was very upset that they had that additional stress and pain that they went through as opposed to being allowed to pass peacefully. But that, if again, I've had clients, they call the paramedics, they give the living will to the paramedics, and then they're surprised that all of a sudden, the CPR, and I went to law school instead of medical school for a reason, but doing all those things that paramedics do, when they thought they were just going to be transported. And I can't give the advice, don't call the ambulance. You have to call the ambulance. But if the intent for everybody is that no heroic measures are going to be taken, you should do the MOLST form with the doctor. A named healthcare agent under a healthcare power of attorney can do the MOLST for their family member. It's one of the few times that the family member can actually, let me step back. For the healthcare power of attorney, the living will, as long as you're awake and communicating with the doctor about your healthcare, what you say goes. For the mulch form, even if you're still capable of communicating with the doctor from time to time in a rational fashion, your agent is still allowed to do the mulch form for you. So it's not unusual for our older clients, particularly if they starting some signs of dementia, some early in the diagnosis, that they've done a healthcare power of attorney that names one or more of their family members as their agent, and then it's that agent that actually does the mulch form with the doctors. The mulch form you have to do with a doctor. It is, in addition to being in your packet, it is available online. So I have a lot of clients that will look at it and decide whether or not they want to have the conversation with their doctor about preparing it. But it has to be done with somebody who has a medical license. So either your doctor or nurse practitioner in the office. And it is much more specific than the living will. So the living will really just governs whether or not you want to be on a respirator or feeding tube at the end of life. So you're terminal, you're in a coma, or you have an end-stage condition. The mulch form applies as soon as you execute it. So there are some doctors in town that will do it for 25-year-old clients. But the 25-year-old clients are saying, give me everything. So we recommend that you look at your documents every 5 years or so. Not that you need to change them that often, but we have started reminding clients, because we don't always necessarily know if they've done one, that even if they think their documents that they've done with me are fine, that if they've done a mulch form, they should make an appointment with their doctor. They should pull that out and review it and make sure that it's still appropriate. I have a client just updated one recently because she's had a continuing decline in her health, and her existing mulch said she wanted everything. And she had come up in to see me to update her living will to say that she just wanted to be made comfortable. But thankfully she was one that had given me a copy of the mulch. So when I compared the two, I was able to send her back to her doctor so that she could update so that there wouldn't be a conflict between the two.
Does the doctor keep this on file? Do you, where does this reside?
So the mulch form, the doctor will usually make part of your medical records, and then the doctor will typically give you a hard copy that they want you to hang either on your refrigerator, or because now so many of us have stainless steel refrigerators so we can't hang anything on the back of the front door. So when the paramedics come, like those are two spots that the paramedics have been told to look for those types of documents. A lot of clients do is, CVS actually sells plastic envelopes, those kind of clear plastic envelopes that have a hole at the top, so that you can put it in and then get one of the little 3M hooks to hang on the back of the door, and then the envelope will hang right on the hook on the back of the door. But I also have some clients who think that does not go with their decor, and they refuse to hang it somewhere where we're going to be able to find it, no matter how often the kids say, can we put this someplace a little bit handier? And we've gotten a couple phone calls from kids going, we kept trying to get them to hang it on the back of the door. We don't know what they did with it. Honestly. In Washington County, that's a little bit less of an issue because most of their doctors are going to be emeritus practitioners. So if they've done the mulch form with a doctor who's an emeritus practitioner, even now most of the specialties, even Hagerstown Heart is now emeritus practice. That if they've done it with any of their doctors and the paramedics come and take them to Emeritus is going to be able to see the most in their medical records. If they're taken to Emeritus and they're put on a helicopter to be sent down to the Washington Medical Center, it'd be a lot better if we had it hanging on the back of the door and we could put it in the copter with them as it's going.
So they need an original, not a copy.
No, they can have the original.
But say if I kept a copy, there's the original hanging where it's supposed to be, and I kept a copy. Is the copy going to work?
A copy will work.
Okay.
So of all the documents, the healthcare power of attorney and the mulch form, the originals are least important. All the doctors will take copies.
Okay.
So it's, when clients execute healthcare powers of attorney with us, we always give them one to keep at home, one to give to their alternate agent, or their, usually alternate agent if we're naming a spouse, somebody who's, the first person who's not living in the house with you. So if they get an emergency phone call that there's been an accident, they already have it. And a doctor's copy to make part of your medical records. And we've got a fair number of clients that will say, well, that's great, but I see 10 doctors, can I have 10 copies? And we will make them as many copies as they need.
I have a question about that. I have that for my husband. We're going to our son's for the holidays in Delaware.
Okay.
Can I take that with me for that, or can I use that out of state?
So I started with saying that it was a two-part form. So the healthcare power of attorney and the living will.
Right.
What we have found is if you take it out of state, all the states will acknowledge the first part and will recognize you as an agent to make your husband's medical decisions. Some of them will not recognize the second part. So if your husband says, I don't want a respirator or a feeding tube, the other state may look at you and want you to verbalize that and give them that instruction as opposed to following instructions in your husband's documents. Which has been a nice development. I've been doing this for a long time now, but before the states started talking to each other about these types of documents, I had one set of clients that wanted to get a healthcare power of attorney in every state on 95 because they were snowbirders and they took the RV down every year, and I don't think she really trusted him driving the RV anymore. And she was like, I just never know where the accident's going to happen. And I said, I don't think we need to go to that extent. Because it's going to be an accident, they're really just going to want your health care power of attorney. So if you're listed as his agent, they'll talk to you. If you're not able to talk, your son's name and cell phone number is there, they'll call your son's cell phone. If he's at the living will stage, he should not be driving the RV up and down 95. Even though I'm pretty sure I've had at least one male client continue to drive the RV up and down when, end stage lung cancer. He should not have been driving the RV anywhere much less on 95. So my clients that are traveling, particularly my older clients, in addition to the extra copy for the doctors, a lot of them will ask for the extra copies for each glove box for the car, saying, we just don't know where we're going to be, where there's going to be a medical emergency, and that way, we know for sure that we have it. And what I have recommended to them, to a lot of my clients, and I actually had to have my kids do it for me, on the cell phone, to use an ICE number. So ICE stands for in case of emergency. If you're in an accident and the police or the paramedics have access to your cell phone, and there's a way that even with Apple phones with the password, that they can get to the ICE number. They can't get to anything else, but they're supposed to be able to get to the ICE number.
Is that a nationwide thing, Jeanne?
Mm-hmm.
ICE.
Yeah. Okay. The MOLS form is, so for years, the bar associations have been trying to get all the states to make this consistent. It would be nice if there was one healthcare power of attorney in Livingville that you could use for all 50 states. So even if you were driving to see the kids for the holiday, or you were driving up and down 95, that you knew for sure it was going to work. The states don't play nice together, and they all want to use their own form. For a while, there were a lot of 5 wishes floating around. Have any of you seen the 5 wishes document? It's a version of the healthcare power of attorney. We are starting to find healthcare facilities not accepting 5 wishes, which is something that I didn't anticipate, and I can't remember the organization that was putting out 5 wishes, but they were essentially coming at it that, you can go online, you can buy our form, all 50 states will take it, and now we're finding that not all of the 50 states will take it. The MOLS form I think is going to be the first document that pretty much all the states take and adopt. So it's gonna work well for Maryland, because they're trying to get them all to call them medical orders for life-sustaining treatment, as opposed to Maryland order for life-sustaining treatment, so we won't have to change what we've been calling it. So Pennsylvania now has one, the PULSE, the Pennsylvania order for life-sustaining treatment. You know, my dad did one in New York. There's no great acronym for NYOLST. But, you know, we think that's the document that will be the first one to kind of become nationwide, so that if you have it, it should apply wherever you are. But it's also the one I find clients are least likely to have a copy of. You know, even though I know the doctors are giving them a copy when they complete it, or I don't know where it goes between their doctor's house and when they get home. You know, we almost always end up having to have the kids call the doctor's office to get a copy of it. And what I tell my clients is, when you do it, you want to get a copy and you want to review it, because all the doctors now are doing it on their iPad. You know, and the technology is great when it's working, and you know, but mistakes happen, and technology happens. So, you know, when you get it, you actually want them to print out a copy of it, and review it and make sure that it says what you think it should say, particularly if you're doing one for a family member, that you haven't cut off a source of care for them that they might need. And there's a lot of myths out there about those documents. I still run into clients that say, well, you know, it's a waste of time doing this, none of the doctors take these anyway. You know, I've been doing this for 30 years. I have not run into a doctor that would not take this form for the last 25. You know, and from a practical standpoint, what we see is, if you've done the living will, there's not as much chance that there's going to be a family member weeping and wailing in the hallway, asking them to do the exact opposite of what your documents say, that the doctors will be paying any attention to, if the family can see, you know, your handwriting, that these were your choices. You know, Maryland doesn't want me to delete the choices you don't want in that document. They want you to initial it, so that the healthcare providers and your family members can see that it was actually your wishes. But you know, there's dysfunctional families. I've got a niece that, you know, 3 times a year she still takes to social media to accuse my husband of murder, because, you know, he did not put his 87-year-old mother on a respirator or feeding tube in accordance with her living will. But her birthday, Mother's Day, and one of the Jewish high holidays, that is on social media. Thank goodness my husband does not spend any time on social media, but saying, you know, if only she was still here, you know, and lovely woman, had not been healthy for 30 years. I was married to her son. She was not a healthy 87-year-old. You know, the thought that she would still be here at 94, and, you know, flying up to Boston to celebrate the high holidays with her niece, with her granddaughter, you know, very unrealistic scenario, but one that gets played out on social media all the time. Best to not friend your family members on social media. So those are really the key documents for taking care of your family members while they're here. We do recommend that if you're having a conversation with your family member in time that they're still capable of exercising their testamentary intent, that you get their affairs, you know, that you do a will, or that you do beneficiary designations, that you look at those types of things. You're going through enough stress taking care of your family members in their last couple of years as their health is declining, that why not make that process as easy as you can? And there can be times that not taking care of that is just creating issues for future members of the family. If you've got minor beneficiaries that are going to inherit, you want to make sure that there's a trust for them at least until the age of 21. And I always just feel ridiculously old when I say this, but there are very few 21-year-olds that are capable of inheriting money anymore. They just mature a lot slower than we did. I was married and I bought my first house at 24. My kids at 27 and 23 and 9 months are nowhere close to that. So if they inherited any money right now, they would probably have more fun with it than I would have at that age. But I had a mortgage payment. Yeah. We have individuals with special needs. We don't want to leave money outright to a special needs beneficiary. If you're taking care of parents and you've gone through the process of getting them qualified for Medicaid, you want to make sure that you're looking at your own documents. We've had a couple times where we have qualified mom or dad for Medicaid. One of the kids died without a will, and the default, and one was not married, so everything went back to mom. One was married but did not have kids, so half of it went to their spouse and half of it went to their parent. Thankfully, that is the one time I have had to tell an individual that the default in Maryland. So if you're married in Maryland and you don't have, and pretty much the same in West Virginia, if you die without a will in Maryland, if you are married and have kids, your spouse gets half, your kids get half. If you're married and you don't have kids, your spouse gets half, your parents get half. So that was the one time I had to tell a spouse that her mother-in-law was getting the other half. And unfortunately, mom was already on Medicaid, so it pretty much kicked her off Medicaid, and the money just went to paying for the cost of her care. Spouse only gets it all if mom and dad are already gone and there's no kids. If not married, no parents, no kids, goes to your grandparents. If your grandparents aren't here, then it goes to if it goes to so it goes up and down your family tree. So if your parents aren't here and you're not married and not have kids, it goes to your siblings and your nieces and nephews. If you're the only child, then it goes to your grandparents, then your aunts and uncles, then your cousins. So it kind of keeps going, cascading up and down the family tree until it finds the closest twig on your tree. The myth we hear most often is if I die without a will, the state of Maryland gets everything. The state of Maryland only gets everything if you are the very last twig on your family tree. And in theory, it's supposed to go to the education fund. One of these days I'd actually like to track that. If I could figure out a way to track that to see if that's what actually happens. And for a lot of clients, when I kind of run through that with them, they're okay with it. But every once in a while, I run through it, and you can actually see somebody twitch. And I'm like, okay, so that's somebody that we need to make sure doesn't inherit any of your stuff. But when you're taking care of family members, you want to make sure that your own documents don't end up causing issues for them. And if you are serving as the financial power of attorney and there's not an alternate named, I recommend having your family member, if they can, update the financial power of attorney to make sure there's an alternate that's named. If they're not capable of making that change at this point in time, I recommend reading the documents closely. I know my document always gives an agent the ability to appoint a successor. As soon as we have somebody who has to take over, that's the first thing that we look at. If there isn't an alternate already named, or we've got concerns about the health or the availability of that alternate agent, that we have them execute, and it's just a simple one paragraph. It needs to follow the same formality, so you just can't handwrite it and sign it. You can handwrite it, sign it, but then you need the two witnesses and the notary. So So you have to execute it with the same requirements that you executed the financial power of attorney. But you know, we had two brothers who, you know, the primary and the alternate, serving for mom. Mom was 97 at Summerford, no longer capable of signing documents. And they were both getting on a plane to go tour World War II battlefields, I believe, in Europe. And before they got on the plane, we made sure that they signed something so that if anything happened to them while they were traveling, or if anything happened to mom while they were thousands of miles away, that we had somebody that was capable of immediately reacting and that was local and that we could get to them. You know, and a lot of times, particularly if you're taking care of a spouse, it's very stressful. And sometimes we actually see the physical health of the caregiver spouse decline faster than the spouse who needs care. Particularly with Alzheimer's and dementia, it is a 24/7 stress. And you want to make sure that you have thought about what happens if for some reason you can't serve in that role anymore. All clear as mud so far?
So you, for the financial power of attorney, you should have an alternate. What about for the health?
For the health,
Same thing.
you know, morbid estate planner, you know, I always recommend that you have alternates. And that if you don't have an alternate, it's because you thought through it and that statutory default will be fine. You know, so, you know, my dad named child number 4 and child number 5 as the agent, as the alternate to child number 4. Again, because if something happened to, you know, brother 4, then he's, you know, the statutory default is 5 of us in the hallway outside his room trying to agree upon things. And child number 4 was, you know, if any of us is the mediator, it's probably him. So him not being in the hallway is going to make that process a little bit more difficult. I started with, I'm a little unusual in that I don't necessarily think everybody needs to have a will. I think everybody needs to have a plan. You know, so, you know, again, picking on my dad, it's a good thing he's so far away and doesn't know any better. 6 kids. So, you know, naming us as beneficiaries on his house and expecting all 6 of us to be able to sell his, you know, clean out and sell his house and get to settlement, just a disaster. You know, so he finally, you know, would do the will so that, you know, Stephen will be in charge and just Stephen has to be in charge of selling it. But, you know, if I was an only child or, you know, me and my best friend was, you know, my only sibling, you know, a lot of times with family members, that you can use beneficiary designations and get your assets to the same place and kind of avoid the probate process. So how many of you have heard that probate's an awful process and you should avoid it at all costs? Now, I know you're all lying because there's a, you know, but probate in Maryland is not a bad process. And sometimes we would rather have the family go through probate to make sure that assets are getting to the right beneficiaries in the right manner, you know, the minor kids or the beneficiaries with special needs. But, you know, if you've only got a couple kids and they're all adults or you're the only child, you know, naming beneficiary designations on all those assets can certainly streamline the process. And if you're a caregiver for an individual with dementia that we're worried about long-term care at some point, you know, there's ways to do that will kind of start the Medicaid clock running, to kind of give more options for care for your family member. You know, and I lose track of my years, but 2006, 2007, you know, lots of facilities built in Hagerstown. You know, many more beds available for individuals than when I first started practicing a little bit before that. But that said, finding a bed at the right facility at the right time can be very difficult. And we have lots of family members that say, I'm gonna care for them at home as long as possible. And almost always, as long as possible is 3 months longer than you should have. It is very difficult to go from home to a facility, and you never, we almost need them to fall and break their hip so that they can go from the hospital to the facility. Maybe not break the hip, but bruise it sufficiently that they're gonna need rehab. But going from home to a facility can be very difficult. And again, nobody anticipated COVID. We had a fair number of families that could not get into facilities, or were reluctant, or needed to, they either couldn't get in because the facility had just kind of closed down during COVID, or there were a couple beds available, but they were very reluctant to put their family members there without knowing when and how often they would be able to get in to see them, to make sure that the transition was going well, that they were getting the level of care that they anticipated. And I had a client who, she lived to be 94, had a son with special needs, had kept him home the entire time. For at least 15 years, I have been trying to talk to her about group home options so that when she eventually passed, and they never think they're gonna pass. They get very mad at me when I say when, and as opposed to if. I'm like, unless you know something I don't, it's definitely a when. But it was very traumatic to him, and we had difficulty finding a spot for him. There were no family members that were able and willing to accept him. So at 65, he had always lived with mom. And then we were struggling to find a group home situation where if I had gotten her to move on it, we could kind of ease him into it. He could have been coming home for dinner, spending the holidays with her, so that at least there would have been some constant in his life at that point. But I get it. I keep telling my kids that we're going to sell our house when my husband turns 70 because it's going to be too much for us to keep up with. But I recognize it's a lot easier for me to say that at 55 than when my husband actually turns 70. I'm like, I like it here. I don't want to sell yet. I want to live here. I want you to hire help and bring it in and take care of me, despite the fact that we've had 13 knee surgeries and there's 27 flights of stairs that we have to go up and down. So I recognize that I'm going to end up being just as unreasonable as so many of my clients when I get to that stage. And I try to remember that when I'm talking to them and making recommendations. And I had to have this conversation with my husband when he started taking over as financial power of attorney and healthcare power of attorney for his mom. She was in failing health, didn't really have dementia, but a lot of her physical issues were leading to UTIs, which essentially presents as dementia if you haven't had a family member with that. And my husband and his brothers meant well, but they had a tendency to be a little paternalistic to start with. And they were trying to take away all decision-making from their mother. And I was like, all of you have made bad decisions during your lifetime. Turning 87 does not take away our right to make bad decisions. It takes away our right to make unsafe decisions. But if she wants to send $25 to the crackpot charity that calls her every other week, she's got plenty of money. She can send $25. If she starts sending $25,000, we'll have a different conversation. But if it's bringing her joy to support these charities, and she's been doing it for 20 years. It's not like all of a sudden. So she died in 2015. 7 years later, and 2 addresses later, those charities like her enough that they still her mail still follows me around. But it's important to remember that they don't necessarily lose the right to make all decisions. You don't want them making unsafe decisions. But I've had 2 brother-in-laws file bankruptcy. They have made plenty of stupid decisions during their lifetime. And turning 87 just did not invalidate that for my mother-in-law. But the unsafe decisions, her thinking that she was going to stay in the house by herself was a decision that we overrode her on. And, you know, and I know I'm gonna be this way. You know, we got the necklace, the life alert. You know, she didn't really like that, didn't go with her outfit. You know, so we got her one that was, you know, it looked like a Fitbit. But if you didn't move enough during certain periods of the day, they assumed that you had fallen and they would call. And, you know, my mother-in-law was in the middle of watching her show, and, you know, the phone was all the way on the other side of the room, so she decided that she wasn't gonna answer the phone. She heard the message, still decided not to get up and go call them back, and then was surprised when paramedics busted through her door 8 minutes later. And she's like, "Oh, this was uncalled for. Answer the phone." But unfortunately, you know, she would never wear it. And she, you know, to the best of our calculations, she was down in her closet for 3 days before we got the next set of paramedics to go busting through the door, because she wouldn't use anything that would tell us if she wasn't. And you know, she has all sons, so they don't talk or text as much, so that, you know, it took 3 days for them to realize that none of them had been able to connect with her in 3 days. And unfortunately, at that point, you know, she was dehydrated, ended up in the hospital. You know, and she kept insistent, "I'm going home." We're like, "Yeah, no. You can send as many $25 checks to the crazy charities as you want, but, you know, we're selling the house." So I know, I'm only supposed to talk for an hour, I think, and I'm just about over that.